practice. And Peter has done some amazing things in the social media and the traditional media world in protecting his clients. And he actually has done some work for our firm. And so I was very excited when Peter agreed to be on our show. Peter, good afternoon.
Good afternoon. Thanks, Mark. Thanks,
okay,
Jeff.
Peter, let's talk about your topic, because it's a topic I have to deal with every single day, and it drives me crazy, and I don't have enough hair to pull out anymore. Talk to us about social marketing and the rules.
Fair enough. Well, social media has proliferated enormously over the past couple of years. In fact, exponentially. Here's some just quick stats, and I have to write these things down because math is not my forte, and there are a lot of numbers. Radio, which we all are familiar with, took 38 years to reach 50 million users. TV, 13 years. The Internet took 4 years. The iPod, 3 years. And the topic of the day, Facebook, reached 200 million users in less than a year. So we're talking about massive scale here.
Wow.
And what we're talking about from the legal side of things is how do we counsel our clients to protect themselves in this fast-moving and dynamic area. And the way we have sort of counseled our clients is to look at social media as having multiple layers. In multiple layers, what I mean by that is that you have a lot of different users, you have a lot of different content sources. You have your employees, perhaps authorized. You have your employees who are not authorized, meaning they go home at 9 or 10 o'clock at night and they log on and stay on for 4 hours and post whatever they feel like posting. You have third-party content users who respond to your Facebook page. And you have what I like to call the crowdsourced people, the people that you actually reach out to create content for you, to create that buzz, to harness that social media. And with all of those layers, you need to remember what you actually are. You're not just simply a company anymore. You're now a publisher. You're now potentially an advertiser.
That's interesting. You're a publisher.
Yeah, and what that means is that there's a set of rules now that you need to at least be aware of. And trying to operate under these rules isn't as hard as it sounds, but you need to be aware of that. So what that means is whatever you're putting out there for the public, or your employees are putting out there for the public, has some sort of legal consequence. You need to know if you have copyright. Have you cleared your copyright? Have you cleared your trademark? Have you cleared rights of publicity? You need to make sure you tie that all up in a nice box to make certain that if somebody posts a photo, for instance, if my daughters and I are having an ice cream at our favorite ice cream shop and a photo is taken and it's posted on, and I post it on the Facebook page of my favorite ice cream shop, what happens if I'm walking down the streets of Boston and an MBTA bus comes driving by with this on the side is a wonderful advertisement for the ice cream shop with my face, my daughter's faces on there? Is that a problem? And it is. And you know, just because you put something on a put something out there, publish it on a social media site, doesn't necessarily mean all rights have been released.
Sort of like when you